This is a short presentation I drop into CLEs from time to time called The Three Eras of Legal Research. This isn't exactly a historical look at legal research. It's more a consideration of the materials that we use to conduct our research and how that might influence our understanding of the practice of law. It also informs my philosophy of practice as a research attorney. So here it is, the three eras of legal research. I break it down into three periods: the era of print, the era of search, and the era of find. The first era, the era of print, dates back to the 12th century, which is why print is in quotes, because movable type didn't come into existence until the 15th century. But sitting where I do here in front of my laptop, I do remember a time most recently when I was conducting research in the print volumes. I remember that time, and so I use that shorthand for the entire period. This era is used merely to define that period of time when we began accumulating material for or in the service of the common law, dating back to the 12th century, first with the plea rolls, then with yearbooks and their abridgments, and finally with the reports. Now, this accumulation of centuries worth of material was, for scholars in the 19th century, really the raw material from which the common law grew. For folks like Christopher Columbus Langdell, the law was a science and the library was our laboratory. Now, that's never been a universally held understanding for what the law is. One special challenge with that concept is the continued accumulation of materials. Unlike the laws of nature, human-made law is not immutable. It changes from time to time as business practices change, as social norms change, as technology advances. So does the law. We change the law to accommodate our current circumstances. So how is it then we can still maintain, even today, a concept of the law as a science? Some of that has to do with the West key number system. West key number system is a taxonomy of the law. Most of us are probably familiar with the key number system. What happens is a case comes into West, an attorney editor reads the case, pulls out a point of law, and assigns that point of law a key number from the index, from the taxonomy, and places that at the top of the document where it becomes a West headnote, available then to attorneys to use as a research tool. We can use that key number, that unique key number, to identify the same principle of law in the same jurisdiction or other jurisdictions. And the important thing here is that that key number system is not static. It develops over time, and new topic numbers, new key numbers are added as the law evolves. And the fact that that was able to happen, this author argues that West's influence may have saved the myth, what he calls the myth of the common law, from what looked like its inevitable demise. So even though we're adding more and more materials, the evolving key number system still treats the law as a classifiable phenomenon, reinforcing this idea that the law really is a science. And so during this period of print, we really rely heavily on the key number system and topical indexes. Of course, there are other topical indexes. The key number system wasn't the only way of organizing the common law. There were other systems. In addition, the statutes themselves are topical indexes of the public law. You probably know that the statutes are merely prima facie evidence of the public law. Same thing with the Code of Federal Regulations and other regulatory materials. We rely heavily on topical indexes to get to the print materials we needed in this first era of print. So what happened after that? Well, I marked 1973 as the end of one era and the beginning of the search era. Of course, that's the advent of what was called computer-aided legal research, or CALR. In 1973, Mead Data introduced the first Lexis terminal. And under these circumstances, in order to get what you need from the materials, you need to conduct or put together a search as part of your research. You needed to conduct a search to get to your materials. And in the early days, it looked more like a three-step process. It looks much different than it does now. In the early days of this period, it was typically a three-step process. First, we needed to identify a database. What were we researching? Case law, Texas statutes, the Federal Register. What were we looking in? So we needed to identify the database first. Then the second step was to put together a query, probably a Boolean query. And then finally, third, we would review our results. Hopefully, there were only a handful of results. We didn't want a million results. We wanted maybe 30 tops. And hopefully some of those were relevant. Some of them were likely to be irrelevant, just mishits, we used to say. But we wouldn't want a big grouping of results. We wanted just a handful because we didn't have all day to review every document. Those documents were delivered to us in reverse chronological order, the assumption being what we wanted to see first was the most recent document. Now, that's not the way it looks these days. It also doesn't look like this. It's just curious to me that despite the fact that we're digitizing more and more information, that our legal research platforms don't look like this. This is you probably recognize this as a Bloomberg terminal. Graphs, charts, tables, all kinds of things here, all sorts of data analytics to aid our colleagues in finance. Even though we're digitizing more and more information, our front end doesn't look like this. I think there are a couple of reasons for that. One is I'm not sure that there's enough data yet being digitized to actually get this kind of material. You may be familiar with things like judicial analytics from Thomson Reuters, where you do get some of these charts, and those are very cool tools, but the availability of state materials is notoriously hard to get a hold of. Pacer's been around for a while, so the dockets, which is the source of this information, works really well if you're looking at federal judicial analytics. If you're after state trial court information, you're mostly out of luck, so it may not make sense to put some of this information front and center on the major legal research platforms. But the primary reason why our platforms don't look like this is it was intentionally made to look more like Google. Here is Decisis, for example. This is a recent product from Lexis being sold to bar associations. Here is Casetext, and you see some common themes here. You have a centralized search box. You have the ability to narrow by jurisdiction if you wish, but your first step, just as it is with Google, is just to run a search. You're not finding a database first, you're running a search, and then you're reviewing your results delivered in order of relevance. You get the most relevant result first and the least relevant result last. And you may get a million results. Doesn't matter, because if you don't find what you're looking for in the first couple of results, you're likely conducting another query rather than doing a filter or additional keyword searching. All of this is meant intentionally to look more like a Google search. For whatever reason, all of the providers of these services felt it was made more sense to have this what looks more like a consumer-friendly sort of research platform. Here is Westlaw Edge. And as you can see, the litigation analytics is available not on the front page here, but with a separate click into those materials separately. So where is the science in this? Well, we've handed that off, of course, to our colleagues in data science. Folks putting together the algorithm are the folks who really own the science at this point when we're running our natural language searches. That doesn't mean we're no longer professionals. It doesn't mean that we're not reviewing materials with a critical eye, but it does mean that when we rely on this kind of search for our research, that we have less ability to trace where the materials came from. The science is with our colleagues in data science. That takes us to 2010. What happened in 2010? Well, this is a bit of a artificial date here. I grabbed the publication date for this Wired article, which proclaimed that the web is dead. Long live the internet, but the web is dead. The idea here is simple. It's just that the web is just one application that functions on the internet. If you look at your phone, there are all kinds of applications there that rely on the internet, but very few of them require you to conduct a search. So the paradigm is once again shifting, and this kind of makes sense. I like the example of someone traveling to a new city and wants to know what a new good restaurant might be. How do you find that good restaurant? Do you conduct a search, or do you reach out to your colleagues in a network? The folks who are building websites know how to use their web marketers who take advantage of the basic principles of SEO, of search engine optimization. So in essence, when you're running a search, you're relying on the marketers to give you the information you need in many respects. So would you rather rely on that person, or would you rather rely on your network of colleagues to get you the information that you need? And you're seeing this, I think, on the legal research front as well. Here's a practical law. There's a whole new class of legal research materials, generally referred to as know-how materials. These are essentially answers. And rather than you can run a search here, of course, to get to the materials you need, but it's just as easy, quite often, just to browse to the relevant material. And you can see as I log in here, I've got just these friendly faces. These resources are giving me the information that I need. I ask for the information and I get it. I'm relying on my network, as in this case being provided to me by Thomson Reuters, but it could also be my network from LinkedIn. It could be my network from an association. Those improved tools are not relying on search to get me the information I need, but relying on my network of individuals. So that's the three eras of legal research: print, search, and find. And of course, the main point here, one main point, key takeaway, is that we're still using print materials. The paradigm is shifting, but as researchers, I think it's important to use the process that makes the most sense for the project at hand. I think we're being influenced quite a bit by marketers of these new platforms, especially the artificial intelligence platforms. We're often told that lawyers are slow to adopt new technology. I don't necessarily think any of that is true. I think more likely attorneys are very, very busy doing the work for their clients. And it's as professionals in the area, we're often using the old tools as well as the new ones. There may be a resource in the basement of the state law library, especially if we're talking about legislative historical material that hasn't been digitized at all. It may not be available digitally. I may have to go to the basement of the library, put in a request, and wait for the forklift to return with a box where the materials I need might be found. But I also use the AI and analytical tools. I connect with my colleagues using those resources. I love the new know-how resources, and I every day conduct a Boolean style search depending on the project at hand. We use them all based on the project. Although the paradigm has shifted, this shifting in the paradigm, I think, does more to influence our understanding of what the practice of law is, rather than direct us towards what kind of process we should use in order to perfect or perform our legal research project. So I look forward to your comments on this video. You're welcome to reach out to me. Here's my contact information. My email is mike@graypaperlegal.com, or give me a call at 612-666-7300. Thanks for listening.